Good afternoon. I'm Toby Edelman. I'm a senior policy attorney in the D.C. office of the Center for Medicare Advocacy. I want to add my thanks to all of you for attending our summit this year, and I want to thank the sponsors of our litigation panel, AARP and SEIU, the Service Employees International Union. We at the Center work closely with both organizations and appreciate their tremendous advocacy and support over the years. Justice Sotomayor spoke at a Bar Association meeting last week. I think she was channeling Kathy Hurwitz. Justice Sotomayor said, quote, "We need trained and passionate and committed lawyers to fight this fight. Our job is to stand up for people who can't do it themselves. Right now, we can't lose the battles we are facing," close quote. In these tremendously challenging times, Justice Sotomayor challenged us. She challenged lawyers to fight for the people and issues we care about, to speak for those who need help in speaking up for themselves. And she challenged us not to give up, no matter what. Lawyers have stood up in these times, bringing case after case to stop the dismantling of our laws and institutions. Not all lawyers have answered Justice Sotomayor's call, of course, but the public interest legal community has. The public interest legal community, our lawyers, our paralegals, and our other advocates continue the fight. I'm delighted to be introducing our litigation panel today, whose 3 members represent the best of the brilliant and effective public interest bar in our field. Bers is the Director of Litigation at the Center for Medicare Advocacy, Sarah Summers, Legal Director at the National Health Law Program, and Maame Gyamfi, Senior Lead Attorney, AARP Foundation. Ali, I turn the panel over to you.
Good afternoon, and thank you, Toby. And I also want to say thank you, Toby, for what you have done for nursing home clients and nursing home residents. For nursing home residents in this country, you have transformed and protected the rights and dignity of nursing home facility residents for over 4 decades. So thank you, Toby. Good afternoon and welcome to our panel on advocacy in the courts. I am Bers, the litigation director at the Center for Medicare Advocacy, and moderating today's panel, we will be exploring how strategic litigation can protect people's rights, expand access to justice, and dare I still say, drive systemic change. So our 2 panelists bring deep expertise and frontline experience in using the courts, not just as a forum for justice, but as a lever for advancing equity and reform. So first we have Sarah Summers, Legal Director at the National Health Law Program. Sarah and her colleagues at NHELP use litigation to challenge barriers in Medicaid and to protect the rights of everyone served by Medicaid. Which of course includes millions of people, and we know, thinking back to the very first slide we saw this morning, 12 million people, I believe, was the figure, who are dually eligible for both Medicaid and Medicare. And given current events, I also want to emphasize that NHELP, maybe not single-handedly, but almost single-handedly, prevented or halted the Trump administration's efforts to implement work requirements in Medicaid during the Trump administration's first term. Thank you, Sarah and NHELP, for that, and we'll be hearing some more about that. Also joining us is Maame Gyamfi from AARP Foundation Litigation, where Maame is a senior attorney. And Maame and her colleagues litigate for older adults, and they tackle issues in healthcare, housing, employment, and civil rights. Maame's work ensures that older adults have a strong voice in the legal system and that systemic inequities are addressed head on. So thank you both for joining us and to talk about advocacy in the courts, and especially with regard to healthcare issues and thinking also about how non-litigators might be able to participate in these issues. So Sarah, if I can start with you, if you can talk, and let's see if your slides are up, if we advance. There we go. Okay. So if you could talk to us about what are the legal theories that healthcare advocates should be aware of, and what are some key healthcare related cases and issues that we should be watching right now?
Thanks so much, Allie, and thanks to the Center for Medicare Advocacy for having this wonderful summit and inviting me. And I'm going to talk about two sort of big buckets of types of litigation. I'm going to talk in a very broad sense about administrative procedure, and then I'm going to hone in very sharply on Medicaid. So I'm going to start first talking about a case that, how many people have heard of this? Loper-Bright. And I just want to say, as an aside, it kind of blows my mind as someone who's spent, more than 25 years toiling in like the most hyper-technical, esoteric legal issues, to have this case have become such a talking point among mainstream journalists and even people who aren't that interested in law. But it did, in fact, have a big impact on Medicare, Medicaid, and a whole host of other programs. So let me take a step back. What this is about, and this phrase has been used at least once today, Chevron deference. And what this is about is the extent to which courts have to defer to a federal agency's interpretation of a statute. In particular, Loper-Bright was about, and Chevron were about federal regulations. I'm going to leave aside, this doesn't affect the world of Medicare fair hearings and the like. This is about regulations. And with Chevron had a test that had been in effect since the mid-1980s, which is when a court is trying to decide if you should defer to a regulation, did the statute directly address the issue? If no, if it's ambiguous or it doesn't, it's silent on your issue, then the courts defer to a permissible interpretation of the agency. This had been going along for 40 years without a lot of problems, but it's a real bugbear with the conservative bar and conservative judges and justices. And so finally the dominoes were kind of set up, and here comes a case out of, not Medicare, not Medicaid, not anything that impacts our day-to-day work, but it was about regulations governing commercial fishermen and the paying of observers on board. So again, a very hyper-specific issue, but it has massively broad implications because the court took the opportunity to overturn Chevron. And the quote from Justice Roberts' opinion is, it's unworkable. There's an eternal fog of uncertainty. I disagree, but I'm not the Chief Justice of the Supreme Court. So it's inconsistent with the Article 3 of the Constitution that gives power to courts to interpret statutes. And it's inconsistent with the Administrative Procedure Act, which doesn't direct courts to defer to agency interpretations to the same extent. So there was a lot of discussion about this before the case was heard and before it was decided, and a lot of very dire predictions. And I'm going to say, I think in the environmental area, that's kind of a whole different animal. But I will say, for now, in the Medicare, Medicaid area, it's not clear that this is going to be the cataclysm that people might have feared. And I'll tell you why. It's because courts actually were not afraid to not defer to the agency. Courts were perfectly happy to say, no, the statute says this and not that. No, you're wrong. No, we're not going to reach that issue. So it was worrisome, and what it is, the main threat I think it has opened up is so many lawsuits, so encouraging so many people to jump in there, encouraging big firms to reach out to their big clients and say, hey, remember how you hated this? Let's give it another try. Which leads to the next administrative law case. Again, from another part of the legal world that doesn't affect us. It was about fees charged to merchants for ATM transactions. And what this entity wanted to do was challenge a federal rule that had been finalized many years ago. There's a 6-year limit on that. 6 years after the rule has been finalized, that's the time period you have to challenge it. But not so. What the decision said is, as soon as you, an individual, an entity, are injured by it, then that's when the clock starts ticking. What this means is it's evergreen. this particular truck stop that was complaining about the ATM fees, that didn't exist back then. There's a lot of industry backing of this. It's not just the mom and pop truck stop that was interested in these fees. So this one, I think, actually is more of a sleeper and a little bit more concerning. And that we're already seeing, again, sort of the renewed interest in challenging things we thought was settled. And I'll just give you the third leg of this stool. I won't spend too much time on it, but this was about the Securities and Exchange Commission, which has long been a bugbear of the financial industry because they have the power to adjudicate fraud and other malfeasance in connection with securities trading and activities. And they didn't like that. And so what the result of this decision was that the court said this is actually like a trial, or this is like a suit at common law, so you need to give people a jury trial. That just totally defanged the SEC. It is a much bigger deal for a prosecutor to take something to trial than to do the internal SEC proceedings. So between the three of these things, we're all looking at a real new frontier in administrative law, coming to Medicare regulations, Medicaid regulations, and any number of federal regulations. So, again, it's still bubbling up there. About 6 months ago, I decided to write a fact sheet on how Loper Bright has affected Medicaid and Medicare, and it was a big ellipsis, TBD. So I'm going to go back and see what's happened in the next 6 months. So that's topic number one. And now I'm going to zoom way in on Medicaid. And let me just say, Loper Bright is, if you are facing it, litigators out there, we have fact sheets about how to deal with it in Medicaid and some theorizing, and we've been working with other public interest groups. So, reach out to us. But let's get to Medicaid. Has everyone heard of Medina versus Planned Parenthood of South Atlantic? Have anybody? Ooh, well, there you go. So, excited for new blood to hear about this exciting topic. Let me take a step back again. Since Medicaid was passed in the 1960s, individuals have gone to court and to argue that provisions of the Medicaid Act were violated. Eligibility rules, coverage rules, choice of provider rules, et cetera. And it wasn't until the 1980s when the court started getting more conservative and some of these theories were bubbling up, the question started to be raised, like, why do you have the right to go to court and enforce Medicaid? The Medicaid Act doesn't have anything in it that says you get to go to court and enforce these provisions. But that's always the way it's been. But in the 90s and into the 2000s, the court started to really narrow what you could enforce in Medicaid. And it has, when I started at NHELP, it was 2002, and a decision came out that freaked everybody out in the world of Medicaid enforcement. And it was looking like the end. We have managed to hold on for 25 years, and we're still holding on. And we're very excited about that. But here is the question that's presented. One of the things about this case, Medina, is that it's right there in the name. This is tied up in all the litigation around Planned Parenthood. There is a provision in the Medicaid Act that says any individual eligible for Medicaid can get assistance for any institution or person that's qualified who undertakes to provide them services. What happened was, after a lot of activism and sort of these sting videos against Planned Parenthood, many states tried to end Medicaid's participation in the Planned Parenthood's participation in Medicaid. Now, it's important to know there's a tiny sliver of abortions that are covered by Medicaid. It's just almost, it's a very, very narrow exception. But what Medicaid covers is family planning, basic services and supplies, basic, prenatal, postnatal, a variety of that area of health services. They get money. In many areas, there's not another provider around that can do that. And so this would be a huge blow to people who rely on Planned Parenthood for a lot of basic primary health care. So, but anyway, so this was one of the few areas in Medicaid where there was a division among the courts as to whether an individual could enforce it. And so there was a lot of cases that came up, and finally the Supreme Court has heard Medina. We have an explainer about it that I can share with Allie to share with others if they're interested. But we were worried because just a couple of years ago, in connection with the Nursing Home Reform Act, a case called Talevsky, which more of you may have heard about, said that the Medicaid's Nursing Home Reform Act was enforceable. And we thought if the Supreme Court finally talked about it, it might finally put it to bed. But no, it's reared its head again, and again, it's all tied up with the Planned Parenthood questions. The oral argument was April 2nd, and I read in Politico, Planned Parenthood's totally going to win. And I read in the Washington Post, Planned Parenthood's totally going to lose. So that gives you an idea of how the oral argument went. We don't know. We will see in June. But there is still potential for the Supreme Court to come back and say, actually, we're going to even further limit the extent to which individuals can enforce Medicaid. It is perhaps more likely that they might say a lot of Medicaid is enforceable, but not this part. And again, in trying to deal a blow to Planned Parenthood, it's going to have implications way beyond Planned Parenthood, way beyond family planning and sexual and reproductive health services. It could be any kind of provider. And because a lot of Medicaid beneficiaries are in a managed care world where it may not be as relevant, there's still plenty of areas where Medicaid beneficiaries and dual eligible beneficiaries need to be able to choose their provider. So watch the space. We'll see what happens.
I'm sorry to interrupt, but do you think the Talevsky holding would still stand even if the
It could, but we'll see. You know, we're hoping for the best, fearing the worst per usual. The last thing I will say is on work requirements. And I really want to say thank you, Allie, very kindly for the credit for the work requirements litigation. And I will say indeed, my dear colleague, Jane Perkins, who's been at NHELP for 40 years, was the mastermind behind this theory. That said, we had excellent assistance from our friends at Jenner and Block, our friends at Munger Tolles, and those private law firms who helped us greatly. And we also, this may segue into a question you asked me later, we have partners among legal services and legal services-like organizations. Our co-counsel in these cases were the Tennessee Justice Center, Legal Services of Southeastern Missouri, Arkansas Legal Services, New Hampshire Legal Assistance. I'm probably forgetting other, Indiana Health Justice Center, but without them we wouldn't be able to do it. They have the connections to the clients and they give us the invaluable on-the-ground support in addition to doing all of the litigation in those cases. So work requirements, we were able to defeat them because it was a type of federal program where the administration approves an experiment or pilot project. And these work requirements were supposed to make you healthier because working makes you healthier. That was their theory. And we were able to argue that that was not a reasonable conclusion there. As we know, as we speak, who knows what's going on right this minute, but when I last checked, work requirements are still very much in the mix in reconciliation. It's, it's a huge fight. It has real traction with people who don't understand a lot about Medicaid or healthcare in general. And so if there is legislation, well then what we did wouldn't be possible because it's not, legislation is a whole different ballgame. That said, right now, legislation that they're proposing wouldn't take effect for several years. And so in the meantime, a whole bunch of states have these 1115 waivers poised to go. So watch this space, Every day you delay is a day saved. Anyway, I hope I didn't go over my time, but so that's it.
Great, thank you very much. And thank you. Maame, if you could tell us a little bit about cases of importance to people who rely on Medicare and also put that in the context of litigation as a tool for activism and what non-litigators can do as well.
Okay, absolutely. So first of all, my name is Maame, like a mother. It's not that popular in the United States, but it's all the rage in Ghana, where my family originally comes from. So I would consider myself to be an activist / lawyer. So, I'm part of that do something crew that says, why aren't they doing something? Why aren't they doing something? They should be doing something. And so for me, advocacy in the courts is what doing something looks like. So today what I'm going to talk about very briefly is first, how can we use the law and courts to protect benefits and enforce rights? And let me just tell you, what you just heard Sarah say, she is absolutely so humble. What NHELP did with work requirements was literally life changing, okay? And, you know, when we watch the movie's a 2-hour movie, but what they don't tell you is how you have to find the plaintiffs. What they don't tell you is you have to find the law. What they don't tell you is everyone and their mama is calling you and saying, if you make bad law, it's going to, I mean, they don't tell you all that part, right? And then all of a sudden the case is being, you know, appealed and it goes to the Supreme Court, okay? We don't say, we're in the Supreme Court, can't wait to see you, Sotomayor. What we say is, oh, wow, right? And then you hear people start talking, they say it's a 6-3 Supreme Court. It's a this Supreme Court. And you get very nervous, okay? And then you have to, when she was talking about, oh, yes, we work with these different groups and this, everyone has an opinion, it's not easy. So what they did literally changed lives, okay? Next thing is, I'm going to talk about some few Medicare and Medicaid cases that we should be watching. And then finally, how non-litigators can help. So let's first talk about the power of legal advocacy. So I'm a DC gal, I grew up in DC, and in general, folks mostly told us, we hate lawyers, right? We hate lawyers, there's too many lawyers, you bump into everyone in DC, it's a lawyer. But I can tell you one thing, and we saw with the past 100 days, issues came up, well, where's my lawyer? Where's my lawyer? We need some lawyers, and why? Because we have tools, right? I love my policy folks because what they're able to do is that evidence-based research that we can use as part of our briefs, okay? There are people like me who all you have to say is, hey, the baby is sick, and I'm like, I'm there and I agree with whatever you want. But there are other people who that doesn't work on them. And you need to show them evidence-based research about what you're trying to do. And so we love our policy folks, we love this. But I gotta tell you, when you tell me a problem, the first thing I respond is, who can we sue, okay? And part of the reason is because there's different pieces that we can use in the law. If something bad is happening, right, we can try and sue and get a preliminary injunction, okay, to stop it, to buy time. When Sarah was talking about, hey, this thing goes maybe 6 years, you know, what will happen in between, right? To buy time, we can use a preliminary injunction. If the court issues a decision, we can appeal and try and get a stay. Again, buy time, right? Let's look at some of the things that happened between 2016 and 2020. We were able to stem the tide, right? So don't forget about us lawyers, because we're here, we want to sue, we want to help people out. People come to us when they are having their worst moment. Okay. They can't believe this happened. They come to us for their worst moment. And we want to help. And we have to find the best strategy possible to be able to help. Another tool that we have, in addition to us being able to sue, is we also can use amicus briefs, where we educate the court about how their ruling is going to impact, let's say, a population. Or sometimes we educate the court, hey, you think this law means one thing, but actually this law means something else. Or we educate the court, this is what Medicaid really is supposed to do. And so those amicus briefs, to me, are incredibly important, because actually, I don't even think them as only educating the court, but a lot of the press, remember how we had someone from the press here earlier? A lot of the press picked that up and are able to actually talk about what's happening. The last thing I would say is, the other way we use law as a tool is also to come up with strategy, right? So when Sarah was talking about Loper Bright, well, guess what? What's good for the goose is good for the gander. If they're going to lose Loper Bright and say, hey, we're not ignoring all these agency regulations using Loper Bright, we need to too, right? Now that things are coming down, say, hey, let's sue under Loper Bright. We don't want them to be able to, like, whatever, defer to the agency. We want to be able to say this is wrong. So again, law, there's so many different pieces that work, right? You have going to Congress and your various representatives and advocating in front of them. You have going to the agencies and talking to in front of them. But we also have the law, where people can sue and try their best to get justice. And that is what we do. We got a problem, who can we sue? So, first set of I chose these specific cases, 3 cases, because I wanted to show you times when people have been advocating for things for years, and they were able to get them right. And again, there's still litigation, but I really want to make sure people understand that when people say, hey, we're continuing to fight on this specific issue, we know that this issue is right, we know that it helps people, don't give up, because things can change. So for years, when I first started, people always said Medicare should be able to negotiate with drug companies, okay? And people were like, that's never gonna happen, this and this. There was actually a special carve out that the Medicare drug companies got that nobody else had, right? And that was actually the only way Medicare Part D actually got passed, okay? And what happened in the Inflation Reduction Act of 2022, they passed part of that law. Medicare can now negotiate prices with drug companies for certain drugs covered under Medicare Part D and Part B. This was a major victory, okay? One of the things when I'm going to talk today, I'm going to talk and kind of bring the people in the room. And so I just want you all to know, why was this so important to people, right? Why was this so important to Medicare beneficiaries? Well, one of the things that happens that's great, again, with the policy folks, is they do all this research and they show us what people were actually living through in terms of the skyrocketing prices of drugs. And I know an AARP, Lee Purvis, has done a lot of work following the skyrocketing prices, right? But what I want to talk about is what the people were doing, okay? For many people, they couldn't afford the cost of their drugs, and so we would talk to people who the husband and wife would take turns taking medication. People would sell everything they own to purchase their drug. People would split their drug dosages in half, right? Some things would just absolutely forego getting their drugs filled. And then all of a sudden, they would say, again, I have Medicare Part D. I have this. How come this drug is so expensive? So again, with this law being passed, folks were like, hey, maybe we can get some kind of relief. And I do want to add, I'm specifically talking about the Medicare drug price negotiation, but do know the Inflation Reduction Act had so many other really good, strong prescription drug provisions. I'm just really focused on this one, because I'm talking about cases. Well, needless to say, the drug companies and trade associations were not having it. And they really launched a furious fight in several different federal district courts around the country, where they basically sued to stop the drug price negotiation program from going forward, alleging violations of the United States Constitution and the Administrative Procedure Act. One of the things that we did, again, law as a tool for social change, is we joined with Center for Medicare Advocacy, we joined with Justice and Aging, we joined with Medicare Rights Center, and wrote an amicus brief on behalf of older adults to really educate the court and the press and the public about why this law was so important, okay? And folks were thinking that, oh, by the way that they've kind of dispersed these cases, and of course they were strategically filed, we'll say, to certain districts, that, oh no, we were gonna get some bad rulings. But actually, to date, every court that has ruled on the merits has actually ruled in favor of the government and ruled in favor of the law being constitutional. We've gone through, I think, most of the district courts, and so now we're starting to get the rulings from the Circuit Court of Appeals, and we've got one recently from the Third Circuit, and in fact, they found that the law was constitutional. So stay tuned, let's keep on looking, but like I said, history made, and it's going on. And I will say, because this is a law, that's why they're going to the Constitution, the APA, but having said that, it's not so easy to erase. Next, we have the Federal Nursing Facility Staffing Rule. Again, history made. For the first time, CMS sets minimum staffing requirements, and specifically these requirements. First of all, having a registered nurse on staff 24/7, and secondly, the 3.48 hours of direct nursing care per resident per day. There are some exemptions to that. In addition, in terms of the actual implementation, I think it was like 2 years, 3 years. But I want to point out, this is history made, because this, again, were folks who, for decades, were pushing for this, okay? Charlene Harrington, decades pushing for this. Elizabeth Halifax, decades pushing for this. Toby Elderman, decades pushing for this. I mean, people were, Lori Spasteka, I mean, people were really doing research after research after research. I'm bringing the people back in to show the dangers of understaffing. So I'm going to share with you some of the dangers of understaffing. And again, remember I told you how when we hear a problem, who can we sue? So AARP Foundation has actually had several cases against nursing facility change, suing them directly for their understaffing. So what happens when you have understaffing? You don't have enough staff to be able to provide care to the to the residents, right? So what's the first thing? People don't get their meals, and you see a lot of people with weight loss and dehydration, okay? One person is helping someone move when it really should be 2 or 3, and they drop them, okay? You'll see people will not get moved at all, and so you'll see lots of wounds, pressure wounds. I mean, we have like a parade of horribles. Again, we're having a nice afternoon. I don't want to go through all of them, but some of them will have people will actually see their bone because they haven't been moved. You know, some of my cases, and in fact, we got reported in the news where people are laying in their own feces for so long, the feces is coming out from the top of their shirt. I mean, things that you would not imagine, okay? And then we won't even add in what happened with the private equity coming in and buying the thing, okay? So this change in the rule, I really need to say, was life-changing. There had been some individual states that do have some kind of staffing rules, but this was a huge, huge change. Needless to say, the nursing facility industry was not having it. So there were 2 lawsuits that were filed, one in Texas, which is by the trade association and some local nursing facilities, and then another in Iowa. And the case that in Texas, again, Center for Medicare Advocacy and AARP also led amicus briefs there. Again, number one, educating about why actually they have the rule, what they need to do with the rule, and then secondly, talking about what people's experiences are when they do not have enough staff in these facilities. In Texas, I think in early April, the court ruled and actually vacated the nursing facility staffing rule. Then in the Iowa case, that one right now is still continuing, but we'll see exactly what happens. Oh, I should have said something before too. With regard to the Medicare drug price negotiation case, one of the things that happened was that when the administration changed, folks were saying like, oh, well, is this administration still gonna defend the rule? And a lot of people were thinking it's not. But actually the administration has continued to defend the Medicare drug price negotiation rule, okay? With regard to the federal nursing facility staffing rule, folks were wondering, is the administration still going to defend the rule? And in fact, to date, the administration still has defended the rule. Now, there is some talk that maybe that will change soon after this whole reconciliation thing is what we all, but I do want to say one of the things I think is really important when we look at legal advocacy, we have to be very careful about assuming that, oh, just because this case was filed in a court, in a district where, oh, I just noticed that the judge that was appointed by either a Democrat or a Republican, I automatically know that that's how this person is going to rule. Now, there are definitely certain judges who you can tell how they're going to rule. Okay, so let's keep that clean. But to me, I always say, because we're about the issue, we are going to, number one, describe the issue the best we can. We're going to pick the best law we can to pursue it, right? And then if they disagree with us, we're going to appeal. So I don't feel that we have to approach these things with a defeatist attitude, like, oh, dang, I got to sign this kind of judge, it's over. No, what we need to do is figure out ways to put the best case forward to be able to win. Last case I want to talk to you about is Brown versus DC. So this is a case that my office brought on behalf of DC nursing facility residents. And it was under the ADA and the Olmstead, okay? And this is what happened. They would have a person who, let's just say, broke their leg, went to a hospital, and then went to the nursing facility, okay? And they were in the nursing facility for so long that they now needed to go back to the community, but they had no transition services or any way to go back to the community. And the way the case actually came to the attention of one of my colleagues was that she was going to the nursing facility and noticed all these people were walking around, and she was like, well, what are these people doing here? They actually didn't really need nursing, they needed nursing facility level of care, but the way they were thinking, they could be in the community, right? And so because of the integration mandate, which says that states and public entities must serve people in the most integrated settings possible, then we sued and said that that DC should actually provide transition assistance for these people with disabilities to be able to actually move in the community. And the reason why this is important is because we don't want to have a society where people are warehousing people with disabilities. if they actually have services in the community that can be used, right, and available, then we want people to be able to have the help that they need to get from the nursing facility to the community. So real quick, the federal court had a landmark ruling, and they said it is true that physically disabled nursing facility residents are some of the most vulnerable members of society who require meaningful assistance to effectuate their transition to the community. The district's Olmsted plan places too much burden of transitioning to the community on nursing facility residents themselves, thereby effectively transferring to them and the nursing facility staff the district's obligation to integrate persons with disabilities into community settings. And I'll give you an example. As you know, because most of the people that you get into the nursing facility, you lose your apartment, right? And so they didn't even have phones to call to see how they could get out. They had no idea where to even go, no one to even take them to look at an apartment. So that was one of the things that we sued for, to be able to get people to have. So now, quickly, what can non-litigators do? First of all, and I think it's a theme that we've been hearing throughout the day, be in the fight. Keep our eyes on the prize and our soul to the goal. Do not get discouraged, okay? I'm telling you and I'm pointing you out some of these cases because even though you see the case, these are things that people fought for a long time to get, and they got them. They got them. Next, part of being in the fight is doing your part. Submit comments to proposed rules when available. They're trying to take some of that away, right? But when you can't, make calls to representatives, and also support these advocacy organizations. Sometimes I don't have the time to be able to do all the different things I want to do, but if I see them send an email out that says, hey, let folks know we're having this thing on Medicaid, whatever, I'm like, okay, let me forward that to some people. Like, whatever tiny thing we can do to give support, let's do that. Next, agree to be plaintiffs or help find plaintiffs, okay? It's very difficult to find plaintiffs. You have a good issue, someone should sue, but it's hard to find plaintiffs. And let me tell you why. Plaintiffs are heroes, but like you notice when we said the case, that Brown case, it started in 2010. Okay, we got a decision December 31st, 2024. Think of all the people who were there. I know for me, again, because I work in AARP Foundation, a lot of our clients sometimes pass away before they even get their victory. But at the same time, these plaintiffs are the reasons why we're able to go forward. Next, share your story with media, social media, and the community. Policy staff, please continue to publish those reports. They are critical to us when we're trying to do our cases. And then let's make sure we communicate the information. And then finally, I say to everybody, self-care, rest if you must, but don't you dare quit.
Thank you. Thank you, Maame. I really like hearing about the Brown case in particular, not only because of the amazing victory that AARP was able to get using Olmsted. Olmsted, for people who don't know, is that integration mandate that Maame mentioned, but also because it actually started 1 year before the longest case that I've worked on, which is the observation status appeal rights case, which now those appeals now are finally happening, and people are able, some people who are placed on observation status in hospitals are able now finally to appeal for inpatient coverage of hospitalizations, which just, I think, goes to show that, yes, these cases, and particularly these reform cases, can take a very long time, but they are still worth doing. And I just want to make sure, do we have time for a couple of questions?
Unfortunately, we do have to cut it short to get back on time. You guys are absolutely wonderful. Thank you so much. Can we please give them a round of applause? We're pausing this conversation now, but please reach out to Maame, Sarah. Thank you.
We are heading into another 15-minute break, so we will be regathering. When will that be, Jeff?
We're going to cut it short to 10, so we will be back at 3:30.
3:30. Thank you, everyone.